A warm welcome to the Digital Freedom Fund Speaker Series. I'm AC Coppens of The Catalyst, a boutique agency based in Berlin, working on how science, innovation, and new technologies shape creative work and society. So no wonder we were kindly asked by the Digital Freedom Fund to host this brand new series of talks aiming at exploring how we can make better use of the competition law framework to protect digital rights. This speaker series will approach different issues like what the recent German ruling on Facebook means, or the discussion within the EU on the topic, what can be learned from previous cases, and much more that relates to curtailing platform power and make this know-how accessible beyond the expert spheres. And I am not an expert myself. I'm not a competition lawyer, so I'm entitled to ask also more basics questions to make it all clear for everyone. And you can remember for later on, there are no stupid questions. So now, a couple of housekeeping rules for everybody. Please make sure to be muted and have your camera off for now. Gladly use the reaction buttons that you have when you love something. I mean, you see this little button below. You can applaud, you can make a like, you can smile, you can laugh. Well, we will have stuff to laugh for sure, even if it's competition law. And exactly. And so use the reaction button so that we can have a human experience also. If you have a question, write it on the chat. Also, anytime during the conversation, it doesn't matter. The Digital Freedom Fund team are the hosts, and they will moderate the chat and pick the most relevant questions for you. Also in the chat, we will be pushing some sources so that you can read, because we have some more complex stuff sometimes. So if you have been writing your questions in the chat and you would like to be called upon to ask your question yourself instead of me reading it, if you want to go live and on camera during the Q&As, please add live before your question, L-I-V-E, and then you will be able to interact directly with the speaker if you wish. And if your question is selected, then I will call you by your name, ask to unmute yourself and ask you to say your role and affiliation, and then ask directly your question to the speaker. And it would be nice if you have your camera on so that the experience is human. I think that's it for the housekeeping rules, and we are all set to go. And before we really start, as it is our inaugural talk today, I'd like to interview briefly Niamh Dunne, who conceived this series together with her colleagues at the Digital Freedom Fund. Hi, Niamh. Niamh is she's a recognized international lawyer and expert in human rights litigation. Sorry, I'm a bit excited. I must say it's my first talk with competition law experts. And she's responsible for groundbreaking freedom of expression cases across several national and international jurisdictions with an impressive track record. She's also the founding director of the Digital Freedom Fund, which supports partners in Europe to advance digital rights through strategic litigation. And we know digital rights are also human rights nowadays. So Niamh, tell me a little bit more before we go on with this series. What inspired you to create this brand new series of speakers speaking about competition law and beyond?
Thanks so much, AC, and thanks so much everyone for joining us today. The lead up to the series has actually been conversations that we've been having with the organizations within the DFF network, who all work to advance digital rights, so human rights in a digital context. In the course of our strategy meetings and litigation meetings, the issue of competition law kept on coming up as something that people wanted to learn and know more about. And we responded to that by organizing a number of trainings, developing materials to make it easier for digital rights advocates to understand how they can work within the competition law framework. We had a workshop earlier this year to kind of really think through potential case ideas. And from that also actually came the idea to have this more public conversation, broadening it to a wider audience and to make this topic more accessible for everyone.
Mm-hmm. So what are your goals? What do you want to move on with this series? Which result would you like to attain?
Well, generally speaking, we would like to actually increase awareness of the impact of the products and services that the big tech giants actually have on our human rights in a digital context. And for those who are working on human rights in this sphere, more awareness on what the possibilities are of using the competition framework to protect them. And finally, a little bit like when I left law school, I was very relieved actually at the time to no longer be having to take competition law classes. But I've seen very much like over these recent years that it can actually is a very exciting area of law and actually can be a very powerful tool to protect our human rights as well.
I'm sure. I know that I've been digging into the subject with you, discussing. Can you tell more to the audience? What is the program? Let's call it Editorial Arch. There is a series of 4 talks, right?
Yes, this is correct. And today we'll start by talking with Niamh Dunne and looking at how we can use the competition law and how it fits into the toolbox, so to speak, of digital rights advocates. Can we use it to protect our human rights? Where do the opportunities lie? And maybe also limitations? And then next week, we'll speak with Constantino Stilianu, and we'll explore the question if, when it comes to online platforms, if big is always bad, because that's, of course, a question that we actually also have to investigate. And we'll ask if it's right to focus on Google, Apple, Facebook, and Amazon and Microsoft and so on, or if we're missing anything by focusing on those big companies. And then we'll finish the series with Thomas Vinje, who's partner at Clifford Chance, who's been involved in many of the important competition law cases very recently, such as the Google Shopping case, but also a bit further in the past, as the different Microsoft cases. And he'll tell us from his personal experience how those cases came to be, and also where he thinks that the antitrust field is heading, also compared here in Europe, compared to the US.
Cool. Okay, this is going to be exciting. I was posting about it today, and I was going to say it's going to be really exciting. It feels a little bit like a crime series, you know, like, and then it happens there, and then there was Google, and then this happens. So we're the big names here. It's all about big tech and taking on big tech. So, okay, thank you very much, Nani, to tell us a little bit more background. And we will go on now with Niamh, Dr. Niamh Dunne. I'm very glad to welcome you today. You are our very first expert of this series, Niamh. Niamh is an associate professor in competition and EU law at the London School of Economics and Political Science since 2015. And she was a lecturer at King's College London and a fellow in law at Fitzwilliam College, Cambridge, we know. So, I mean, good track record here. She has also worked in competition enforcement for the Competition Authority of Ireland, and also as a consultant in competition policy, primarily for the OECD. She holds law degrees from the University of Cambridge, NYU School Laws, King's College London, I could go on. Broadly, Niamh's research interests encompass the areas of competition policy and market regulation. Her work explored the relationship between competition law and economic regulation, public and private aspects of antitrust enforcement, EU internal market liberalization, and aspects of competition policy in the digital economy. And what was actually the reason for this talk today is, in a recent paper, Niamh explored the question that many digital rights litigators have when approaching the topic of competition law in their work, namely, how can laws that on one level seek to ensure that markets work better be also relied on to solve broader societal problems, for example, environmental protection, societal inequality, unfair labor practices, data privacy, etc. So, and she was giving an overview of the recent decisions and investigation of the EU Commission into big tech, and we're going to have a look at it today, of course. And she notes the underlying accommodation of broader societal concern around platform dominance. So this is why she was just perfect for this first talk, enforcing competition laws, how to raise public interest concern and make complaints count. So Niamh, I mean, I would say let's start right away, right? Because of course we know that big tech and regulating people's digital rights is at high stake today. And we want to explore this together. How can competition law protect privacy, enforce data protection, or ensure even freedom of expression? So let's have a look at this, the mechanism, the regulations areas, the possible challenges, and let's go. And maybe let us start with a very basic question. How does it work, so to speak? What are the main EU competition law elements that people should know about?
Thank you so much, AC, and thank you, Nanny, for inviting me to participate in this as well. Great to be here. So EU competition law specifically is quite a broad umbrella of provisions. I think of greatest use to people who might be digital rights advocates who are hoping to strategically use it to increase or protect digital rights. You're looking at what are Articles 101 and Article 102. So the rule against anti-competitive agreements, which prohibits firms from entering into restrictive arrangements with their competitors or with other firms in the market, and Article 102, which is probably the most prominent tool that's been used in this area. To date, it's the rule that regulates abuse of dominance. And of course, if we're talking about a sector which is dominated by GAFAM or GAFANG or however you want to call it, certainly this is very obviously applicable. And there's some interesting cases under both 101 and 102 that have been taken in the tech sphere in recent years. There's also a much broader framework, and there have also been some very prominent tech decisions with respect to merger control. So WhatsApp, Facebook, and Apple Shazam, and Microsoft LinkedIn, where the Commission has sort of dug into aspects of the tech sector in order to decide whether mergers should be permitted. All of those mergers were permitted, and the Commission's had some criticisms of an unduly lax approach to merger regulation in the tech sphere in the past decade or so. It's not so useful for strategic litigation because you can't apply the merger control regulation against firms. It's within the solely within sort of the enforcement power of the Commission. It's only when mergers are announced. There's also the state aid rules, which have been very prominently applied against some big tech firms in recent years. Most obviously, perhaps, and maybe because I'm Irish, I have a bit of an interest in this, but Apple, the 13 billion euro bill for Apple to repay back taxes. So that's again also been used very strategically by the Commission in the tech sphere. But again, it's really within the kind of regulatory control of the Commission, so it's less useful for strategic litigation.
Cool. Can you give us maybe a little bit more detail or examples of a kind of agreements that can be actually problematic? I'm thinking, the no poaching with the big tech firms, like how is it actually structured?
Yeah. So 101, this is our rule against anti-competitive agreements. And the classic example here would be hardcore cartels, where you have two or more firms which get together and they decide to carve up markets, or they set prices or whatever they might be. In the tech sphere, I think this no poach case was a really interesting example. It was actually a US case from a few years ago, but the big tech firms had agreed they weren't going to poach each other's highly skilled staff, and it was held to amount to an anti-competitive agreement. You can also have anti-competitive agreements that are vertical, and actually most of the agreement work the Commission has taken in the digital sphere in the last few years have been focused on the e-commerce sector. So it conducted an investigation into e-commerce markets, which reported in 2017, and it found that manufacturers were imposing very significant restraints on e-tailers, basically to try and curtail some of the really vigorous competition you see in online markets. And the Commission decided, quite unusually, because it doesn't tend to take a enforcement activity against these vertical restraints, it finds them a bit boring actually today, but it decided that this was sufficiently interesting, and it took 9 infringement decisions to date against mainly against sort of resale price maintenance, so vertical price fixing, and against clauses which prevented sales across member state borders, so sort of segmenting national markets. And then if you think of, as I mentioned, that 102, so our ruling about abuse of dominance has been very prominent here. Probably the best example, and it was mentioned by Nanny actually, would be the Google cases. So there's been a number of enforcement actions, 3 to date, against Google thus far, totaling 8 billion euro in fines. So the Commission is not playing around with these cases. I suppose the key theory of harm, the most interesting theory of harm that seems to be arising in digital markets is self-preferencing. So this is the idea that where the big tech platforms have a very strong market position in one sector, they might try and leverage that market power into another sector. So for example, Google was dominant in the search, is very obviously dominant in the general search market, and it was trying to give an advantage to its rather less good comparison shopping product, and that was held to be an abuse of dominance in 2017.
Absolutely. Search to shopping is the most obvious one, right? And this is only for, or not only for Google, I guess. Anyway, so let's pretend there is a breach in regulation. So how does it work? Who takes action?
So actually in Europe, there's many different levels. So obviously at the top of the apex of the structure is the European Commission, which can take infringement decisions with respect to breaches of 101 or 102 that apply to one member state or many multiple member states. And it has the power to investigate these cases and to find infringements, to impose sanctions. It can also enter into settlement decisions, which some people would argue is more useful if it wants to sort of regulate the market rather than fine a problematic behavior in the past. If you are thinking of the Commission in terms of strategic litigation, I guess you would be perhaps thinking about them as a potential recipient for a complaint. And certainly a lot of Commission investigations are started on foot of complaints from either from consumers or from rivals in the marketplaces. The Google search shopping case had literally dozens of different complainants, all of these little small firms who felt they were being pushed out of the comparison shopping market. There's also national competition authorities. So each of the now 27 member states, I feel sad saying that because I'm in the UK, but the 27 remaining member states all have national competition authorities which can investigate and sanction these practices. Again, they are typically very receptive to complaints about potentially anti-competitive behavior. It has to relate specifically to that one country. Some of the member states even have criminal enforcement powers if the cartel, for instance, is considered to be a hardcore cartel, involves some criminal behavior.
Mm-hmm.
I suppose the third level of enforcement is private enforcers. So the Commission has been very keen in the past couple of decades to really encourage greater level of private enforcement by interested parties, private parties who might want to take cases before national courts. So you go to the national court, you claim a breach of EU competition law, and you seek some recompense. Specifically, EU law gives you an entitlement to damages. So if you've suffered harm as a result of breach, so you've overpaid for goods, or you've been kicked out of the market by your competitor and your business has gone bankrupt, you can sue for damages as a matter of EU law, which is quite unusual in EU law. If you're looking for something else, so if you are taking strategic litigation and you're looking for an injunction or so forth, that's going to be governed by national law. So it's going to depend upon the rules of standing, the remedies that are available before each national court. But national courts do have a duty to ensure effective enforcement of these provisions. And so I think they ought to be quite receptive to claims for violations, I would say.
Mm-hmm. But I don't know, but I hear a lot about things that it is really taking really long. So how long does it actually take to see results when you have been, taking the measures and go against?
Yeah, this is one of the really big criticisms of the use of competition law in big tech markets, because it's a residual tool. It's always there. So in the absence of other regulatory frameworks, people are quite keen to kind of invoke it and use it. But the problem is it can take a long time. It is not in any way nimble in most circumstances. So the Google search shopping case, the complaints come in 2010, and the case takes 7 years. It's not until 2017 that we actually have a final determination. The Commission has announced, and there's one case, Broadcom, from last year, that it's going to start taking what are called interim measures during investigation. So if there's an ongoing alleged breach and the Commission is pretty sure that there is a violation, it can impose a kind of interim remedy while it conducts the investigation. And that worked quite successfully in the Broadcom case. You get an interim resolution before you get a final decision. But still, these cases take a long time. If you are conducting these cases before national courts, that's all really going to depend upon how long your national proceedings take. First, you might be waiting for an infringement decision from the Commission, because that helps litigation at the national level. And it's also going to depend upon how slow your courts are. So you probably don't want to be litigating these cases in Italy, because it's going to take you 20 years, I would say.
Okay. And if we have a look now from the consumer perspective, how can responsible consumers actually familiarize themselves with the topic? In which way can they make an impact at all? I mean, what is to be gained by engaging the public in this matter, actually?
Yeah, that's a really good question. So the Commission has been really keen to develop what's called a culture of competition. It's something that has, worked really well with the US antitrust laws in the 20th century. People are very aware of the US antitrust laws in a way that I don't think they're so aware, or at least have not been until recently, of the rather technical field of competition law. So the Commission has been quite keen to involve private enforcers, including sort of sponsoring a directive, a piece of legislation that was intended to make it easier to be able to bring cases at the national level, because they think essentially the more enforcers we have of these rules, the better, the greater I suppose the awareness of the rules, the more likely it is that businesses are going to recognize that they're subject to these obligations and actually abide by them. It is difficult, though, because it is quite a technical field. There's a lot of economics to it. Often the competition rules don't necessarily work the way people think that rules governing competition should work. So, for example, unfair competition is, people think of that as sort of unfairness as the standard. Unfairness is not really the standard in contemporary competition law. It's much more focused on things like making the market efficient and keeping it open. And so there can be a bit of a disjuncture between what people think the rules can do and what the rules can actually do. The Commission has a website with lots of information, and I think the DFF also has some information that you can have a look at. You can find it, the details in the chat. One reason, and I'm a bit of a cynic, I have to say, but I think one reason why the Commission has been so keen to take, for example, the very big cases against Google and has imposed these massive fines. I mean, Google can pay the fines, but €8 billion is still a lot of money, is because it does catch the public attention. It catches the public imagination. I was told that the reason that the second fine that the Commission imposed on Google, so for the Android case in 2018, if you rounded it up to the dollar amount on the day, it was exactly $5 billion, because the Commission knew this was going to be reported worldwide and they wanted a figure that sort of made sense. So you can maybe be critical of that. You can say, well, that's a very clever thing to be doing, to actually be making the point that, the European Commission is here, and even if you think you are invincible big tech, we are here, we can regulate you. You need to think about your obligations in the market. But I think it is one way of catching the public attention, shall we say.
Okay, well, better than nothing, I would say. Actually, we have a couple of remarks coming up and questions in the chat. Thank you very much. Keep it going on. We will pick them in the Q&A section a little bit later, but don't leave it. This is great. I see some comments. Excellent. Wonderful. Okay, so now I would like to know a little bit more what happened recently in the law-tech intersection, actually. And we know that the Treaty of Rome, 57, was the first time competition law that was introduced in the European Economic Community. And I understood that one of the most important things about competition law is that since the 70s, 80s, etc., competition law has become entangled with competition economics, right? However, the digital markets that we have today have a number of recurrent features which can complicate the application of the convention or the old economic tools, so to speak, like being multi-sided markets, benefiting from network effects, having zero price products, because we don't pay anything when we are on this platform, etc., etc. So one of the question I have for you, which is now in the contemporary competition law, is to which extent the more economic approach can and should be maybe retained in respect of enforcement in digital markets. I mean, is it that way, right?
Yeah, it's a really big challenge because the Commission was a little bit late to the party in terms of making EU competition law more economic. So the Americans got there in the 70s and 80s, but it took until the late 90s and the kind of 2000s until the Commission really embraced this idea. So it's only in the last, say, 10 years that the Commission has said, we want to make it about economics. We want to make it very scientific and all about the maths. And now it's faced with this challenge that the tools that it has very emphatically proclaimed, developed, embraced just a decade ago are starting to look like they work less well when you have these sort of different market features. And there has been a number of competition authorities worldwide, actually a large number of competition authorities worldwide have commissioned reports in the last 2-3 years, which look at competition in digital markets, and they all come to slightly different outcomes. So you've got there's an EU report and a German report and a UK report and an Australian report, various US reports. They all sort of take a slightly different approach, but they all seem to say competition law works sort of, but it definitely needs to be augmented, and it definitely needs to be adapted.
Actualized? Yeah, exactly.
Yeah. To the kind of the very particular context here. So there are, I mean, so I guess that would be my.
No, but I mean, it's interesting. Let's go on what's happening today. I mean, can you tell us more about maybe like recent examples of investigation, decisions of the EU Commission into big tech? I mean, you were mentioning a couple of big names just before. What are the most prominent stuff? I mean, that's really interesting for us here in the audience.
Yeah, so the Google cases which I've mentioned are definitely the most high profile. So these are these 3 infringement decisions, one related to the search market, one related to Android, and one related to advertising. So the 3 sectors where obviously Google is so dominant, so super dominant, really.
Right.
Big fines, 2 interesting sort of aspects of the theories of harm. So there's various theories of harm across the 2 cases. One is exclusive dealing. So turns out big tech firms really like to tie their customers into exclusive dealing arrangements, often paying them to do so. There's also a recently started case in the US being taken by the US Department of Justice, which is focused exactly on this, Google paying Apple to pre-install search as the default search engine, as the only search engine in Apple products. The second theory is self-preferencing, which I've already mentioned. So this idea of trying to leverage market power from one market segment to another. Those are the completed cases. There's a lot of ongoing cases. In fact, if we actually just use the acronym GAFA, there is a case for all of GAFA. Yeah. So most prominently, there is an investigation into Amazon. So this began a few years ago, and just last week, the European Commission announced it's planning to go for an infringement decision. So it's issued a statement of objections, which is the basis for an infringement decision. This relates to Amazon's activities in its marketplace. So it's alleged to have a dominant position in marketplace, where it both it provides intermediation services to retailers, but it also sits in the downstream market as a retailer, and it's taking advantage of information, private information, non-public, commercially sensitive data that it collects as the intermediation service provider, and it's using it to calibrate its downstream business. So again, it's a form of self-preferencing. It's focused on data collection, and actually the investigations into Facebook and Google, which are at an earlier stage, are also about this collection and misuse of data, but it's not personal data, it's commercially sensitive data. So you don't have the overlap with, say, the data protection rules. In this instance, there's also an investigation against Apple, which is looking at a claim made by Spotify, the App Store policies. But all of these cases very much focused on, I suppose, the platforms as traders in the market, and excluding other operators from the marketplace.
Yeah. Yeah. Okay, good. No, this is great. Listen, I would like to make a little experiment here, because I have a question, but I'm not sure if it's so interesting for everybody. So I would like to check in the audience if they like the question. I would like to ask you, Niamh, what were the biggest challenges in these recent investigations, and what should be done to overcome such challenges, to adapting the conventional competition tools and methodologies to the digital market? So maybe we could inquire into this for 1 or 2 minutes only, because we're very tight on time. So I want to know, can you write into the chat, everyone, like, yes, we want to know the challenge. So yes, if I can see this or not in the chat, or because if nobody is saying yes, I'm going to move on with the next question. Which will be more about digital rights goals and etc. But I would love to check the challenge. So let us see what they say. Yes. Okay, I have 3. No, you're not the majority. This is not working. Yes, please. Oh, well, yes, please is good. Okay, yes. Okay, so Niamh, can we please take this on a little bit? I would like to know. I know it was an optional question for me, but I really would love to know. So what can be done to overcome this specific problem of conventional tools to digital markets?
There are 2, I suppose, big challenges. The first is how we conceive of market power, because particularly Article 102, the threshold criterion, the gateway is that you need to demonstrate market power. What's the economist's understanding of market power? Being able to raise prices above your marginal cost. If you are Google and you don't actually charge a price for your product, or you don't charge a monetary price for your product, you might people might see it as a price you're paying with your data. It becomes a bit more difficult, and this is why the Commission, I think, it's felt the need to move away from the more economic approach, because it feels hamstrung by these tools which work in a very kind of analog version of markets. But the question the Commission faces, how do we adapt these tools so we can still be economic and we can still be rigorous to these new market scenarios? And there's a lot of economic work being done on that. The second question, I guess, is what do we care about? What is an anti-competitive harm in a digital market? So should we sort of cling rigorously to our established categories of harms, or should we be receptive to recognizing new categories of harm? So the Commission insists that self-preferencing is a long established category of harm. I think that's not entirely true, and the Commissioner has later said that at least it's a new example of these older varieties of harms. If you look at, for example, the decision of the German Bundeskartellamt in the Facebook case, they're actually a lot more honest, because they say this is a new market, it's a new type of harm, and we're going to recognize it as such. So what they don't do, which the Commission insists on doing, is impose a fine, because they say, well, it wasn't clear in advance that this was a problem, but at least they're very, I suppose, proactive, and they're honest, and they're making new case law for these new market problems.
Yeah, and I see a comment of Helena, who is saying that the Commission is consulting on a new tool called New Competition Tool to address many aspects of the digital market. This sounds like an answer to my question. So this is good. Thank you very much for answering this specific question. Let's move on to the next one. I wanted to know now that we go in our discussion to the real point, like the digital rights and the EU competition law, to bring it to this point before you can go on with the Q&As. What do you think, in which ways do the digital rights goals, such as the ones I was mentioning before, like protecting privacy, data protection, freedom of expression, equality, in which way can they align with the goals of competition law policy? How has the EU Commission approached this so far, this kinds of concern in recent actions, for example?
So actually, it's not something that I think they have really looked at in these cases. I'll talk about the German Facebook case in a moment, but the Commission, when it was asked about the German Facebook case, kept on mentioning the GDPR, because it says this is data protection, and we've got the GDPR for data protection. So it has been a little bit reluctant to embrace the notion directly that human rights violations or digital rights violations might be a direct target of the antitrust rules. It's a difficult question how they can be accommodated. I think there's two ways of looking at it. The first is the more indirect way. So what is competition law good at? It's good at making markets work better, which many people would say is a relatively shallow goal. But it is actually an important one, particularly if we're talking about access to essential services for vulnerable people. So how can, at least indirectly, competition enforcement help enhance digital rights? Well, it can give people access in a better quality or an easier or more assured way to the digital environment. Competition law is incredibly good at doing things like forcing firms to compete against each other, stopping them from entering into cartels or even entering into mergers, which might result in an absence of competition, result in higher prices, lower quality service. And if you're talking about things like access to broadband or mobile internet, or even the hardware that you need to get online, what competition law can do is make sure that people actually have the access to these products that they need. And that might seem like a really not a very exciting way of thinking about digital rights, but it's incredibly important, because if you cannot access the digital environment because essentially you do not have the means to do so, you are entirely cut out of accessing this hugely important aspect of modern life. So if you just think about it, even in terms of member states which have put access to welfare benefits online, you have to be able to get online to apply for your benefits. If you can't do that, you're completely locked out. Or even just during the pandemic, and there are a huge number of stories in the UK about families who don't have internet or don't have a laptop. Their kids are stuck home from school for 2 or 3 months, and they're denied access to education because they don't have the access to the digital environment that they need. So competition law, to the extent that it can make those markets work well, can enhance access in this indirect way. Perhaps more contentious is the extent to which competition law can directly provide a way to protect or a solution for digital harms online, what you might call non-competition harms. So things like data protection or freedom of expression, protection from censorship, protection from hate speech or so forth in the online environment. There's two questions I think you need to ask here. The first is, to what extent is competition actually going to help? So to what extent would a digital market make the harm be less likely to be realized? So I think it is arguable that there are certain types of digital rights that could certainly be protected through competition. So in its merger control enforcement practice, the European Commission is increasingly recognizing that quality of data protection could be seen as an element of product quality. So a merger could make data protection less protective, more protective. Having a more competitive environment might force the firms in that environment to compete more vigorously on this particular dimension. That's not a given, though, that competition is always going to be helpful here. And I kind of I took part in a podcast a few years ago where one of the other speakers was a woman from the Open Markets Institute, which is a very progressive competition think tank in the US. And she was arguing very vigorously for the breakup of Facebook. It was the time that Elizabeth Warren was suggesting these structural remedies in her presidential campaign. And she argued, she said, at the moment, Facebook doesn't face any competitive pressures, so it doesn't care about fake news, it doesn't protect against them. But if we broke it up and we had multiple different competitors in the market, it might take it more seriously. But she also said in the same breath that users really like fake news. It's pretty much the one thing they like about Facebook. So they're much more likely to click on a story about how the Pope supports Trump than just a normal, boring news story about tax rates or whatever it might be. And so in that scenario, it really didn't strike me as being likely that if Facebook faces more competition, it's more likely to lose its users to other social networks, that it's going to clamp down on the number one thing that its users want. So I would say in that scenario, it's actually probable that it would be less likely to regulate fake news correctly. So competition isn't really helping there, I would say, or it's not a given that using competition or making the market more competitive would be helpful. I suppose the second question you need to think about, and this is a really big policy question, and one that is raised by this German Facebook case that I've mentioned, is to what extent, if we've got an undertaking that has a dominant market position, so we have one of GAFAM that are very clearly have significant market power in a market segment, to what extent can we conceptualize any behavior that they engage in that might result in digital harms? Can we also say that that's an abuse of dominance merely because they have the market power? So we say market power plus harm to a digital right equals abuse of dominance. This was the Facebook case, just to very briefly to talk about it. So this is the German Competition Authority last year found that because Facebook was engaging in excessive collection of personal data, it required users to sign up to terms and conditions that allowed them to collect essentially too much data. This was an abuse of the German rule on dominance, on market dominance. The case goes on appeal to the Dusseldorf Higher Regional Court. And the Dusseldorf Higher Regional Court says, we don't think this makes sense because so it's an exploitative abuse. You're supposed to be exploiting consumers, but consumers are not losing their data. And actually, the court says, think about the agency of the consumers. Yeah, consumers might just be ticking a box here, but actually, there's no reason to kind of assume they're doing so because they're being abused or exploited. They might just be indifferent, or they might actually find it convenient. And they have a choice. They don't have to use Facebook. It's not inevitable that you need to use it. The case then goes on further appeal to the German Supreme Court, and the German Supreme Court says the agency argument is irrelevant. What's relevant here is that Facebook is dominant. It doesn't face any competitive constraints. It doesn't have to think about what consumers might want in terms of data protection because it is completely, I suppose, protected from any competitive pressures elsewhere. Therefore, that must be an abuse of dominance. So the kind of violation of data protection norms is the abuse there. And you have this really big philosophical divide, I think, in terms of what competition law should be doing. So do you agree with the Dusseldorf court that if it's competition laws about regulating markets, there should be some market link to consumers' exploitation in their role as consumers? Or do you agree that actually there should be a broader, I suppose, more ambitious understanding of what competition law can do, where we have these very strong positions of dominance, these huge, both, so I suppose they have both economic power and they have market power in these segments, these almost unprecedented positions of market power with the GAFAM companies.
Yeah, I think the German Facebook case is really like super interesting. By the way, we will talk about it in not the next, but the one after next session with Dr. Miriam Buiten. So sign up to join. Maybe Anna, you can push the link to if you haven't done it yet. Yes, exactly. This is going to be also very interesting. I see we have questions about the case of Facebook. Oh my God, we have the questions coming up now. So I just a last question from me, because I would really love to ask it, because I wanted to ask, do you believe that the competition law enforcement can really play a role in protecting and promoting digital rights? And if it is a tool that should be in a digital rights advocate toolkit?
Yeah, so I would give that maybe a qualified yes. I think you need to ask whether more competition, and that ultimately at the end of the day, competition law is about protecting competition in the market or encouraging greater levels of competition in structurally less competitive markets. Is more competition actually going to help here? Is it going to force firms to have greater respect for the digital rights of their users, of others in the marketplace? Or conversely, is it likely to prompt them, a race to the bottom in terms of digital rights, where actually, because firms are so busy protecting their profit margins, they're actually going to do everything they can to kind of get there? And, I am a cynic. I don't think you can necessarily assume that Google says it's not going to be evil. I don't think you can take them at face value on that. I think it certainly should be part of the digital rights lawyers toolbox. It's a tool of general application, so it doesn't require any regulatory intervention. You're not going to be hindered by all the lobbyists that are paid for by the big GAFAM companies who are vigorously resisting any forms of regulation in most areas. So it's there and it can work and it can deliver more competitive outcomes, but it certainly has some limitations. We've already mentioned the question of the time it takes for investigations. There's also a difficult question of remedies. So competition authorities and courts are often quite bad at trying to figure out what's the best remedy going forward to make the market work better. And there is this big conceptual question of the extent to which a digital right harm can be approximated to a competition harm, how it can fit into the kind of established framework, and should we be pushing the law in this way? So part of the solution, but certainly not the only thing I think that we should be looking at.
Shall we push the law on this way? This is wonderful. I love that question. Actually, this is a good way to let us push the question now. So, oh God, there are so many questions here. We have, I don't know what to start with. Well, maybe let's start with the Facebook German case. Can the German case against Facebook easily be applied at EU level, or is it very specific to Germany?
Really, really good question. And the answer is we don't know, I think. So the Germans, it was assumed they would proceed under Article 102. And then at the very last moment, they sort of do a bait and switch. And they say, actually, we're just using German law here. We're just using the domestic provision that regulates abuse of dominance. Given the nature of the market, technically under EU law, if they thought there was a violation of 102, they should have applied 102, which you might think impliedly means that actually they weren't convinced that there was a violation of Article 102. And certainly they used a lot of German precedent on consumer protection to inform the findings. After this comes out and after we see the kind of this halfway approach, so there's a violation, but it's only a German law violation, dozens of scholars all piled in with their views as to whether the Commission would be able to do the same thing, or whether it would do the same thing. It doesn't look like the cases the Commission are taking at the moment, 3 of them involve data, but as I've mentioned, it is all about commercially sensitive data, and it's used to kind of exclude competitors in the market. But the German Facebook case has gone back to the lower court. It's been sent back down. They're going to give a final judgment on that. We know the lower court doesn't particularly agree with the Bundeskartellamt, so they are perhaps likely to make a reference to the European Court in Luxembourg, and hopefully the European Court in Luxembourg might tell us a little bit more about whether this fits with Article 102 if we're lucky.
Cool. Okay, good. Hold on. We have another question, which is question on the theory of harm and competition policy metrics, right? And how they can be adapted for digital markets. So do you see another theory of harm other than self-preferencing emerging from, for example, abuses of social media platforms like election manipulation?
So the short answer is, in the short term, probably no, because I think that these are phenomenally scary things that are happening, which are affecting democracy, that are affecting freedom of speech. And of course, the firms can do this because they have this privileged market power, this privileged market position. But it's really hard to conceptualize that as a competition abuse. So at least self-preferencing, the thing about it is it sort of makes sense in a competition scenario, because it's about excluding other competitors from the market. Why it's a bit weird in contemporary competition law is because contemporary competition law is not supposed to care about competitors being kicked out of the market. It's supposed to be focused on consumer welfare and prices for consumers, and there's no evidence in the Google case that it actually was harm to consumers. But at least it makes sense if you're looking at this through maybe a slightly more old-fashioned competition law lens. Whereas these cases, I have to say, I'm not even that comfortable with the German Facebook case, just because really what's going on in the background is the German Competition Authority and the German data protection supervisor really want to apply the data protection laws against Facebook. Except Facebook's headquartered in Ireland, and us Irish people tend to take a laissez-faire approach to some things. And since they can't apply the data protection law, they're using competition law as a bit of a roundabout. That to me sort of makes me a little bit uncomfortable, perhaps in some scenarios, although I certainly have very little sympathy for Facebook on a personal level, for Facebook as a company. So I don't know if these theories of harm really would be cognizable in antitrust terms. What I think, the fact that people are making these arguments just indicates such an absence of really necessary regulation in these other areas. These companies are completely under-regulated in terms of, their as publishers, their responsibilities in terms of, protecting elections and democracy and so forth.
Absolutely with you. I think there are quite a few. So they're trying, it's legit, right? They're trying on the different angles, to get there, right? Yeah. I have another question here. I would be interested to know what augmentation you would like to see to add to economic metrics in the law, and who of the various reports to the most comprehensive look at the other possible metrics. I think you were evoking a little bit earlier in the discussion the augmentation. Maybe you can elaborate on that.
Yeah. So I am the wrong person to ask for this because I'm a very poor competition economist. I think the question is, the difficulty at the moment that I think the Commission faces is that it feels that it is stuck between two poles. So it either has this very economic, very kind of maybe late 20th century view of neoclassical competition economics, which is all about efficiency and it really only looks at things in those terms, or it says we just have to abandon it entirely. And I think a lot of the recent cases really don't seem to be paying any attention to the standards the Commission set itself in 2008, 2009, when it issued its economic guidance. So I think if you were going to augment, what I think you need to do is to have different ways of looking at the same problem, or different ways of building a theory of harm so that it is compelling that actually there is a problem here, and it's not just a problem for competitors. And it's not just a structural problem in the fact that we like markets that are all broken up, because actually markets that are all broken up don't necessarily work very well. I mean, Google is a phenomenally good company in terms of many of the products that it produces. We want Google to keep producing the Google search engine. Otherwise, I would never find anything in my life. We just don't want it to be able to abuse its dominance, to take advantage of that. So I think it's trying to find ways to it's trying to find ways that are both robust in terms of demonstrating harm, but are not caught within this very narrow neoclassical paradigm. As to what those metrics are, I have to say I'm not qualified to answer that question, unfortunately.
Well, you don't look unqualified to me already with that answer, so that's wonderful. Thank you. We have a further question. You mentioned that consumer welfare is at the heart of this competition law. What about the new Brandagian movement in the USA, Lina Khan, that advocate that perhaps democracy should be at the heart of competition law? In this sense, we could perhaps fit digital rights better into this competition law framework. Do you have any thoughts on this?
Yeah, a great and contentious question. I should say, so two things about consumer welfare. First, I absolutely agree with you that maybe if we were having this conversation 15 years ago, so Herbert Hovenkamp, who is my hero of competition law, who has always been very centrist or to the left in the kind of competition law discourse, he wrote this great book called The Antitrust Enterprise, and the very first line of it says, after years and years of debate, we finally have settled on what is the goal of competition law. It is consumer welfare. And that in 2005, I think was true. I think we had agreed that it was consumer welfare. The difficulty was that we didn't really know what consumer welfare meant. So if you were a Chicago schooler, you had this really economic understanding of consumer welfare, which actually would be prepared to give all the benefits to the producers on the basis that, kind of Reaganite, it'll trickle down somehow. In Europe, we've always been much more concerned about the notion that consumers should get a fair share of the resulting benefits. So we maybe agreed on consumer welfare in theory, but we didn't agree as to what its content was. But certainly, yeah, I think that you are seeing a movement away from that in Europe and in the US. So I'm something of a cynic of some of the proponents of hipster antitrust, because it's a classic sort of critical legal studies approach of saying all of this is wrong, but not really providing an answer as to how we fix it. So I feel like critics of the consumer welfare standard in the US, the new Brandeisians, basically just say this doesn't work, but they do very little to try and explain what we should replace it with. Whereas in the EU, and this is something I have done quite a bit of work on myself, we don't really, I suppose, talk about democracy or these sorts of ideas so much. Actually, we do. That is a lie. I'm wrong there. But there's been, since Margaret Vestager took over in late 2014, she really put the emphasis on fairness. So she stopped talking about efficiency, she stopped talking about open and competitive markets, and she started talking about fairness. Fairness for producers, fairness for consumers, fairness, paying a fair share of tax, fairness for the workers who make the goods that we are going to put into the competitive marketplace. And that, I think, is a kind of maybe kinder, gentler way of looking at competition law. It does still raise the question, well, what's a fair outcome if a fair outcome to me looks very unfair to you, because we're in a sort of a zero-sum game? That's more problematic. But yeah, I do think that there is greater scope. And I think that this movement towards fairness, at least in part, goes in tandem with, say, the Google cases, all these big investigations, because one of the big themes in Commissioner Vestager's, in her, at least her policy rhetoric and her speeches, has been people think the digital economy is really unfair. The big tech giants are exploiting us. That's unfair. We need to control them. And back to the point I made earlier about some of these cases maybe being kind of signaling from Europe that we're prepared to control the tech giants. I think those ideas go hand in hand.
We are prepared to control the tech giants is a fantastic way to end this conversation. I think we do not have any questions anymore, and it is 5:28 here, CET. So I think we are approaching the end, unless somebody must make a comment or ask a question now. But we're not finished anyway, because the series is going on, right? Well, so I would say Yes, people say it was very interesting. This is great. Yeah, I know you have to go. That's why we are on time. I just want to make the announcement. I mean, first of all, I want to say thank you so much, Niamh. I mean, even for me, it was absolutely fantastically interesting because I'm not such an expert in this field. You are such a passionate speaker. It was really a wonderful way and very entertaining to learn so much about big tech and competition law. So thank you so much for joining us today for this first talk of the series. Next week, a little bit later than today, half an hour later, we're going to have Konstantinos Stylianou, and I will ask him how competition law can help protect digital rights also, but with a slightly different angle. It will be really very interesting to have him with us. Because we're going to have a look at the biggest company also on the planet, Google, Apple, Facebook, Amazon, with unprecedented power. And we will ask Konstantinos to explore how can competition law address a certain concern and crucial question like why has change been so slow? We had this a little bit also today. How do tech giants typically justify their conduct in the face of such damning criticism? And if competition law is failing us right now, can it or should it play a new role in the digital economy? So it's going to be really interesting. And then the week after, as evoked, we will have Dr. Miriam Buiten, and we'll have the Facebook business model as an outlaw from Germany. This is going to be great, understanding the impact of the Federal Supreme Court decision. And then the week after, as said already by Nani, we will have Thomas Vinje, and we will have learning from the landmark Microsoft and Google shopping cases. We were talking about shopping earlier. This is going to be great. So what do they mean for big tech today? I think it's a great series, and I really hope I will be able to see you in the next weeks all together. So yeah, everybody, thank you very much. Register, maybe also the RSVP is probably going to stay the same, I guess. Nani, maybe you want to say something about the next RSVPs?
Yes, by writing to projects@digitalfreedomfund.org, people can register for the sessions that they want to attend, and then they'll receive the login details as they did today.
Okay, and before you leave, everyone, you have the chance also maybe to save the chat. There is so much here you can reread in case you didn't have the time to make some copy-pasted of the links. I think you can save the chat. If you go at the bottom right of the chat, there is 3 dots there, and then on the top of them, you have save the chat. I would say save the chat because it's great. I mean, Niamh had been preparing really great links, also the Digital Freedom Fund, so that we could really like feed you in case you really didn't have enough after this hour, and probably we didn't have enough. So let's see you next week. Thank you very much, everyone, and bye-bye.